On. So in the last lecture we said that agency is a consensual relationship between two people where one party consents to another acting on their behalf and the other person also assents to acting on behalf of that first person. And when the agent then acting on behalf of the principal undertakes an act, then that legal act is binding on the principal. There's a legal relationship established between the third party with whom the agent acted, usually contracted, and with the principal. We saw that in Diplock, Freeman, Lord Justice Diplock told us that there is an important difference between authority of the agent, which is actual, conferred by express words or implied from circumstances or the conduct of the principal, and apparent authority, which has nothing to do with the relationship between the principal and the agent, but is to do with the relationship between the third party and the principal. And we looked at the practical aspects of apparent authority. We looked at how to establish apparent authority in circumstances, and we looked at a number of cases, including those where the agent appears to be self-representing themselves to act as a person authorized by the principal. Now, so you might come across in tutorials, in exam, there were questions where you have to practically establish on the facts whether someone has got authority, whether actual, or if not, whether there is a chance to argue that there is an apparent authority. So you then, the best way to approach those problems is to look at cases and try to draw parallels with the facts that you've got in front of you and the cases that you've looked at. But we also look at some of the conceptual aspects of apparent authority. So we need to ask ourselves a question. On what basis is apparent authority established in law? What is the rationale, the justification for it? Because after all, the basic premise of basic classical agency is that the agent acts with authority from the principal on behalf of the principal, and it is that which acts as the binding agent, the binding element between the principal and the third party. But in apparent authority, by definition, there is no actual authority. So we need to think about on what basis it could be established. And a number of explanations could be advanced. One is the question whether apparent authority is really nothing to do with agency law, but it's about tort law, it's part of tort law and vicarious liability. Some cases, such as First Energy case, which we looked at in the last lecture, which involved, I remind you, the bank manager who acted without authority to communicate to a client that a loan to them was approved. That case could be justified as based on vicarious liability of the employer for the acts undertaken by the employee in the course of employment. The difficulty with using the vicarious liability explanation is that it doesn't work for many cases, because vicarious liability requires an element of link connection to employment, and many agents will not be agents acting as employees for an employer. There will be no employment relationship. Independent contractors, for example, but also parties who are not in any prior relationship and yet purported to act on behalf of the principal. So the vicarious liability doesn't help us very much. There is another justification that's proved to be far more popular with the courts, and that's the explanation of apparent authority based on Estapel. Estapel, as you know, requires three elements: a representation to a party. That party then has to act in reliance on that representation and act to the detriment, alter their position. The representation in apparent authority is present because the principal makes a representation to the third party that the agent has authority to undertake an act to bind the principal to the obligations. And the agent doesn't need to be aware of this representation. The third party then acts in reliance on that representation, thinking the agent has the authority to bind the principal, for example, to enter into a contract. The third party then says to the agent, yes, I enter into a contract, I agree to those terms, and alters their position, their legal position as a result. This explanation has some difficulties because, first of all, the representation. Right. There's always something with this equipment. What I wanted to show you, not the middle part, but the third part. And there's probably a way of making it. Oh, there we go. That's slightly better. Right. So, with the Estepel explanation, one difficulty is that the representation that the principal supposedly makes is, in some cases, very general. So representation has to be clear and unequivocal to the third party, but in some cases it can be very general. As if you remember in the old case of Beer, the principal merely allowed another person to be present in the premises, and that was and to accept payment from a party who is obliged to pay, and present behind the desk next to some papers was considered to be sufficient to trigger apparent authority. So if we accept that Estepel is an explanation for the phenomenon of apparent authority, we have to say that the allowance by the principal to have someone sit behind a desk is a form of representation. So that seems quite artificial, and a genuine true Estepel would be much narrower. Also, the detriment, more importantly, in some ways, the detriment suffered by the third party can be very small indeed. So mere entering into a contract is considered sufficient to trigger apparent authority principles. So this explanation seems to be suffering from some criticism. An alternative has been suggested by some scholars, and that's the standard contract law principle basis. And that explanation starts from the position that all contracts, I really want to make it just on one page. Okay, not really succeeding in that endeavour.
Is the apparent authority estoppel binding the principle?
Yes, that's the point of apparent authority we looked at. It's to enable the third party to argue that the principal is bound, even though there was no actual authority.
Because the principal gave the agent a manner of authorization in some way, as you said, putting it behind the desk.
Well, it's not manner of, it's a representation. So the courts talk about representation. It's not authorization, because authorization or authority is a question between principal and the agent. So there is no...
The agent can be depicted as a representative.
The agent is seen as having the authority by the third party. So it's a representation by the principal that the agent has authority when actually he does or she does not.
And to...
Sorry, can I...
just one more question, just
yes.
to review. That's subjectively ascertained on the part of the third party?
It is. Well, we talked about the level of knowledge that the third party needs to have and the question of level of inquiries. So if you remember, we talked about the lack of reasonability.
Well,
That's right. So if I could just press on, and we really have quite a few points today. So I'm sorry, ruthless today with the questions because we've got quite a lot to deal with. But I will try to make some time for questions nonetheless. So, sorry, could you live with the screen sort of overlapping? Sorry about that. I can't make it. So the alternative has been suggested by mainly scholars that the doctrine of apparent authority is really based on standard contractual principles. And we're looking at the idea that apparent authority is part of law of contract. In apparent authority, a party expresses an intention, manifests an intention, and what counts, what should count, is how that intention is objectively manifested. And just as much as in ordinary law of contract, the question of whether offer or acceptance has been communicated is perceived by looking at the objective manifestation, how a reasonable person would perceive the presence or absence of intention. So in apparent authority, what we're looking is whether the representation that the principal makes, how it's objectively manifested to the third party. So on this view, apparent authority is real authority. It's a real authority that the principal confers upon the agent. Because like real authority, it is based on consent. And therefore real authority, just as much as actual authority is, as if the agent was operating within actual authority conferred. There are some proponents of these views. One is Macmill, and you will see, or have seen, I hope, in the article put in the pre-lecture reading that Macmill favours the explanation of the case of First Energy as a manifestation, objective manifestation of consent of the bank, that the bank manager has authority to enter into a contract binding the bank. And another proponent of that view is Krebs in his article, for example, which you've got set for pre-tutorial reading on agency. And Krebs is quite famous for the view that agency in general, but also apparent authority, is a form of offer and acceptance model explanation of how agency operates. So it comes back to this importance of objective manifestation of intention to enter into a contract. Now, this view, objective intention view, standard contractual principles view, can be critiqued, and I think really ought to be critiqued, because it doesn't correspond with the principles of English law, but also doesn't correspond to the authorities in English law. So as a matter of principle, it is long established in English law that apparent authority arises and only to favour the third party. It's for the third party to be able to argue that the principle is bound. It doesn't create authority or act as authority from the perspective of the principal. If the principal wants to then argue that despite the act by the agent being unauthorised, the third party is bound, then the principal must do something else, must ratify the contract. So if we accept the standard contractual principles as explaining apparent authority, then we would have to deny this principle and we would have to say that the principle is also bound to the contract with a third party when apparent authority arises, because apparent authority on that view is simply actual authority, that's real authority that's established, and that generates all the consequences that we know from acts by actually authorised agents. So, and that's problematic. The courts have also favoured Estepel view pretty much exclusively, and you will find a number of judgments saying that Estepel is the basis for apparent authority. One example is the case of Freeman and Lockyer, which again I hope you have already looked at. If not, please do so. It's a very important judgment by Lord Justice Diplock in particular. And he says that very clearly, that apparent authority is based on Estepel, but also other cases such as Ocean Frost. So Estepel analysis is to be preferred, but if we accept this view, then we also have to put up with the notion that if it's Estepel that underpins apparent authority, it's a very special form of Estepel, because the representation is quite general. It's sufficient for representation to be very general, unlike in true Estepel. The detriment to the third party can be very small, unlike in true Estepel. And the debate might seem very academic, whether the basis of apparent authority is Estepel or standard contractual principles or something else, but it does have impact in practice, for example, for the ratification question. Whether, if you accept the Estepel view, then it's for the third party to bind the principle to the act, but there is no ability on the principle to keep the third party bound unless they ratify, so it's that ratification point. And it's ratification that we need to look at next. When a third party contracts, for example, with an agent who has no actual authority to enter into a contract, then the third party might argue that the principle is bound on apparent authority principles, but if principle wants to be bound, they must ratify the contract, and that means they must unequivocally express consent, either by express words or implied from the circumstances, but it must be clear that they give authority to that act. And it's a very famous dictum by Lord Sterndale in Königsblad and Sweet case, that when the principal ratifies an act which was unauthorized by the agent, they provide antecedent authority. It's equivalent to antecedent authority. It's, in other words, actual authority conferred upon the agent with retrospective effect to the point at which the agent undertook the act, for example, entered into a contract. For ratification to happen, not only must the principal's assent be very clear, and it must not be left to doubt whether the principal is accepting the contract or not, but also it ought to be the case that the third party must have believed that the agent had authority to bind the principal. And as we see in Wilson and Tumman, it's also important that the agent has acted for another. So the agent must have acted on behalf of the principal, even though they acted without actual authority. It's only then that the ratification can take place. Now, there are some additional detailed conditions on the extent to which ratification is permitted in law. One is that a principal cannot enter into a contract with a third party retrospectively, so ratify an act by the agent, if at the time of the agent acting, the principal had no capacity to make the contract, and case that's often quoted is the Boston deep sea fishing, where the principal was an enemy alien at the time of the Agents Act. But more relevant in present day and age is the case of Kellner and Baxter, that if you've got an unincorporated company, so a company yet to be made a company, so prior to incorporation, then the prospective directors might be already undertaking an act, might be concluding contracts for the benefit of that future company. And when the company is created, the company may not ratify the acts of the agents, of the promoters of the company, precisely because the company was not in existence, was not incorporated yet, had no legal power at the time of the Agents Act to enter into those contracts. The Kellner and Baxter is the classic authority for that. Now, a very important case is Bolton and Lambert, because it illustrates the limits of ratification. Have you had a look at Bolton and Lambert? Yes. So what happened in Bolton and Lambert? What were the facts, if anybody could briefly summarise these? Okay, well, I shall. So we've got a third party who seeks to makes an offer to lease premises from another company, and on behalf of that company, a director acts and accepts that offer to lease the premises. The acceptance of the offer is in fact unauthorised. The manager, the director, acts without the consent of the board of directors. In the meantime, a draft agreement is drafted, a draft agreement is made, and one of the conditions of that agreement is that the third party should provide a guarantee that they will perform all the obligations under the lease. And at that point, the third party doesn't like it and seeks to pull out and withdraw the offer to enter into the contract of lease, to lease the premises. Subsequently, the board of directors ratifies the act, ratifies the acceptance of the offer from the third party. And the question is, was the withdrawal of the offer by the third party effective? Therefore, the acceptance would not be effective because the offer would no longer be there to accept. Or whether the ratification gave retrospective authority, so the acceptance of the offer would have been authorised retrospectively, and the third party is unable to withdraw. Which of these options did the court allow? Was the third party allowed to withdraw the offer? No, absolutely not. That's correct. Now, the question is why? The judgment of Lord Justice Cotton is a good illustration of the approach taken by the Court of Appeal in Bolton. And he says that the rule as to ratification by a principle of acts done by an assumed agent is that ratification is thrown back to the date of the act done, and the agent is put in the same position as if he had authority to act at the time the act was done by him. So it's a contractual principle that the agent acts to bind the principal with authority. It's as if he had authority all along. And Lord Justice Cotton continues, says that when and as soon as authority was given to A to bind the principal, the authority prevented the third party from withdrawing the offer. Because at the point when the authority was granted, that offer was no longer an offer, but it was a binding contract. It had already been accepted by the agent with retrospective authority. So this principle goes very far. You see that the third party seems to be somewhat at a disadvantage here. And the rule in Bolton and Lambert has been criticised, and the court sought to limit it. One limitation, which is fairly common sense, is that principal must ratify the unauthorised act by the agent within a reasonable time. So if they try to do it 10 years later, then that's probably too late. But ultimately, the first point you need to ask yourself, thinking whether the principal can ratify, is to look at what act the principal is seeking to ratify. Is there anything in the contract that the agent was seeking to conclude on behalf of the principal? Whether there's anything in that contract that precludes ratification. And it might be that the contract between the third party and the agent concluded a clause saying that this contract, this act, cannot be ratified by anybody. It's exclusively only between those two people. Or there could be time limitations implied in the contract itself. A good example of those limitations on the power of the principal to ratify is the case of Bird and Brown, which is an old case. And this case involved sale of goods from one place to another. They had to be shipped. And the law is such that if the seller puts goods on a ship, and it takes some time for those goods to arrive to the destination, if the seller finds out before the goods reach the destination that the buyer is unable to pay the price and is going insolvent, so they will not pay the price, then the seller can exercise a power which is called stoppage in transit. They might stop the goods, exercise this power, not necessarily physically, but exercise the power legally as a form of a remedy to preclude the goods becoming property of the buyer. And in the case of Bird and Bolton, the facts were such that the buyer was going insolvent, goods were on the high sea. An agent on behalf of the seller exercised this power to stop the goods, but this was done without authority from the principal. The goods then reached the buyer, and the principal sought to ratify the exercise of the power to stop the goods retrospectively. So if we apply the principle of ratification, we say the authority was retrospective, the act is valid, the goods would have been stopped, and the buyer would never acquire property of the goods. But the court held that because the buyer, under the law of sale of goods and passage of property, had already acquired property rights in the goods, the principal was not able to unvest those property rights. What is once vested cannot be unvested. We're talking here about property rights, not just contractual rights. So it's a thought that the principal could not ratify. Another explanation of this case, which is perhaps more modern, is that there was an implicit time limitation on the principal to ratify, and simply ratifying the goods once they already left the ship and were delivered to the buyer was simply too late. But the wider point I'm trying to make here is that the case of Bolton and Lambert puts forward quite a wide rule, very much in favour of the principal, and there is a concern about the way in which the interests of the third party are represented here. And effectively the third party is at the mercy of the principal. whether the principal seeks to proceed with the contract and ratify or not. And it's thought that the balance of the interest is not rightly struck. The case of Bolton has been criticised in a number of sources, and the references on the handout from the point but C. Kiddermeister, you can treat that as additional reading. But it's interesting that there are some cases, such as the case of Kiddermeister, an old case, which was not cited in Bolton, where a third party was allowed to withdraw an offer pretty much on very analogous facts, and the court reasoned that it was simply too late for the principal to ratify an acceptance of the offer when the third party sought to withdraw that offer. Okay. Have you got any questions on ratification?
Can the apparent authority situation be deemed default agency, a kind of default agency? So if a person is in a certain situation in relation to the principal, they can just be deemed as a default agent in relation to any contracts or agreements they make with third parties?
Well, I'm not sure what you mean by default, but I think what is really important is to look at apparent authority principles as, on traditional view, apparent authority being based on Estepel, has nothing to do with actual authority. Whereas when you just say default agency, that to me suggests presence of actual authority, perhaps implied from the circumstances. So I would say no.
To understand it, there would have to be some element of natural justice. So, as you say, there would be ratification in retrospect. I suppose that would make the situation valid.
Right, so if there is an unauthorised act, and I think that's a good point, which I want to make clear, if there is an unauthorised act, the third party, from the perspective of the third party, there are two choices. One is to try to argue apparent authority, but the other one is try to argue that the principal has ratified the contract. Of course, it is for the principal to ratify, not for the third party, but it's an alternative route of argument that there was something that the principal did that actually gave retrospective authority to the act. Okay? Yes?
Is the authority to the act of your power? So if you're trying to authorize a release, is it if they've done two leases and they only want to authorize one, they have to authorize both? They have to ratify both?
Well, it's a good question. It depends on the terms on which they ratified. So the ratification is consent to giving actual authority to the agent. So it will depend on the terms on which you gave that consent. So it's important that the principal must unequivocally manifest consent to ratify, to give retrospective authority to the whatever act it is that the agent did. So you might look at that, the terms of the consent, and say, well, actually they only authorised one, not both. But it's inevitably, with factual scenarios, it might be that you cannot possibly argue that you have ratified only one and not the other. It might be that sort of scenario. But it will depend on the circumstances of the case. Okay? Right. I shall now like to turn to the second handout for today. So the first of the handout on undisclosed principles. So I should flag up, if you have downloaded this handout last week, then the order of some points, a couple of points, will be slightly different to what it is on this handout, but the content is exactly the same. I shall flag this up. So, next point on our list is to talk about the doctrine of undisclosed principles. So generally, as in Montgomery and Mutual Steamship Association, the judge tells us that the general rule is that when an agent acts on behalf of a principal with authority, then act, the contract, is that of the principal and not the agent. It's prima facie then the common law principle that only the principal can sue the third party, not the agent, and we say colloquially that the agent drops out of the picture. So when the agency, when the principal, when the agent acts on behalf of the principal with actual authority, then the contract is concluded between the third party and the principal. But there is an exception where the principal might not be known to the third party. The existence of the principal might not be known to the third party at all. And in those cases, it wouldn't be right to say that initially there is a contract between some unknown party and the third party. So we've got, in English law, a doctrine of undisclosed principal or undisclosed agency, which can be contrasted with disclosed agency, where agent acts on behalf of the principal and the third party knows that the agent is acting on behalf of another. In undisclosed principal doctrine, the contract is concluded with the third party not being aware that the agent acts on behalf of somebody else. So the agent on that contract incurs liability to the third party and might acquire rights against the third party. Now, the word of caution is we have to distinguish between undisclosed principles and simply unnamed principles. So it might be that the third party is aware that the person they're contracting with is an agent, but they might not know for whom that person acts. So what we are dealing with here is something else, where the third party is not aware at all that the agent actually is an agent, that they're acting not on their own behalf, but on behalf of someone else. What's the position of the third party then? Very famous dictum of Blackburn in Armstrong and Stokes gives us an answer to this. It's when the third party discovers that in fact the person contracting with them acted for somebody else. This is a unexpected godsend, because the third party is entitled to take advantage of it and is able to sue a principal. So the joke here, I think, is suing somebody is a godsend. It's a very good thing to do. So it's an ability here to sue the principal. And the doctrine of undisclosed agency, for the third party to be able to take advantage of it, a number of elements have to be fulfilled on the facts. The doctrine is very well established in English law and not established at all elsewhere in the world, pretty much. But in English law it is well known. And Lord Lloyd, in the advice of Privy Council in Seo Kwan, gives us a summary of the law, rather conveniently. So the first one is that the undisclosed principal may sue and be sued on a contract made by the agent on his behalf, acting within the scope of actual authority. It's important that the agent acts within actual authority. In entering into the contract, the agent must intend to act on the principal's behalf. Those two elements, those first two elements, is something we need to look at more closely. And the other elements are that the agent of undisclosed principal may also be sued and sue. Any defences which the third party may have against the agent are available to the principal. If you think about it, this is just common sense. If the third party thinks that they're contracting with a person in front of them who acts on their own behalf, it's only fair that if they have any defences against that person, they should also have the ability to raise those defences against a person who actually is the principal. The terms of the contract may expressly or by implication exclude the principal's right to sue and the liability to be sued. And again, this is common sense, I hope, that if the third party acts with someone who actually acts on behalf of someone else, but the third party thinks they're acting on their own behalf, then the terms in that contract between the agent and the third party ought to be binding. So exclusion of the intervention by the principal is one of them. So what I wanted to do now is to look at the extent of doctrine before we look at the rationale. So this was the bit I wanted to change the order in which we cover things. So the first, there are 2 points I would like to discuss in a slightly greater detail. One is the element that the agent must act on behalf of the principal within actual authority, and the second is the second element, which is that the agent must have intended to act on behalf of the principal. So the first element is hugely important, that there must be actual authority between the agent and the principal. When the principal is undisclosed and wants to sue the third party on that contract, or the third party wants to sue them. And a hugely important case is Keeley and Maxted and Durant. In that case, there was a corn merchant who was buying some wheat, some corn on jointly on behalf of a company, Keeley Maxted, and himself. And the company told this agent that they can buy the wheat on behalf of the company so long as it's at a certain price. The agent couldn't buy the wheat at that price, so they bought it at a higher price. The seller of the wheat did not know that the person in front of them was acting on behalf of someone else. They thought they acted on its own behalf. Subsequently, the company discovered this, and in fact, both the company and the agent wanted to pull out of that contract. So the seller was rather unhappy. They sued for the price, and they could sue the agent. There was a contract between the agent and who was buying the wheat and the third party. But later it transpired, the third party discovered, the seller discovered, that the agent was not acting on behalf of themselves, but in fact was acting on behalf of Keeley Maxted. And it was the third party who tried to argue that Keeley Maxted, the company, was able to give retrospective authority to the act, to the offer to buy wheat, and there was actually a contract not between the agent who was acting with them, between the merchant who was authorized or lacked authority in this case, and the seller of the wheat. And the question that arose between the court was whether Keeley Maxted was liable on the contract. The House of Lords held no. Keeley Maxted, as the undisclosed principal, was not authorized, did not authorize this contract. Why can we safely say that they did not authorize the contract? Yep.
Because they authorized it at a much better price?
Absolutely, that's correct. So, a party cannot ratify a contract on behalf of themselves done without actual authority, where at the time the third party was unaware of the existence of the principle. So, if you like, when there is no actual authority between agent and principal, and the principle is undisclosed, then the principal cannot both disclose themselves and ratify the act. So you cannot have two of those things. The courts might think it's too indulgent for the principal to be able to both give retrospective authority and disclose themselves and be able to sue on the contract. Lord Chancellor Earl of Halsbury says this very clearly, that agent made a contract on his own behalf without authority of anybody else. The contract was made, and I am of the opinion that upon no principle known to the law could the principal be made party to that contract. And if you think about it, there's quite a lot of force in this argument. He says later that when the agent acts without authority in his own name, that would alter the contract afterwards and make it a very different contract. So he's concerned about the position of the third party. So even though in this case it was actually the third party who was trying to make this argument that the principal ratify the contract, usually it will be the principal who will seek to ratify a contract. And if they are both undisclosed and act without authority, then in fact any one of us at any point could try to ratify any contract that anybody else did, because you are an undisclosed principal and you don't authorise a contract done by someone else. And yet if Lord Chancellor decided otherwise, you would be able to simply insert yourself in the contract done by someone else with a third party. So it acts, this restriction seems to act as a protection on third parties to in fact find themselves in a contract with a completely different person. Of course, if the logic of this argument holds, then we need to be very careful how we explain the relevance of actual authority. Because as soon as the agent has actual authority to act, even though they are undisclosed, the principle, the doctrine of undisclosed principle applies, and the principal may sue on that contract, and equally the third party can sue on that contract too. Even though from the perspective of the third party, it looks as if they're entering into a contract initially with someone else. So the next point that we'll explore, and we'll do that after the break, is in what circumstances the intervention of the principal may need to be limited. So we'll look at that after the break. Thanks.